Welcome to the Roetzel Health Law Hotspot. Health Law Hotspot is a podcast for physicians and health professionals that covers the legal issues and trends that affect the healthcare industry.
Hi, everyone. Welcome to the Health Law Hotspot. I'm Ericka Adler, shareholder and leader of the healthcare practice at Roetzel and Andres. Today, I'm joined by Michael Brohman, shareholder and member of our employment litigation group. And we're going to be talking about a really interesting topic having to do with ADA compliance by physician and dental practices and how to respond if you're being investigated or you receive a letter that accuses you of non-compliance. So thanks for joining me, Michael.
My pleasure.
So this topic has come up recently because quite a few of our clients have received letters from attorneys, whether in the state or out of state, indicating that they believe the practice to be non-compliant with ADA requirements. So I'm hoping you can talk a little bit about what we're seeing in these letters and then talk us through the proper response to provide to that lawyer, or maybe the answer is not to respond. But tell us what everybody should be doing.
Well, the most recent letters that we've become aware of are sort of atypical for this kind of matter. Typically, if somebody, an attorney is representing a disabled party, that attorney will go into a facility, send a letter, or even file just a complaint on behalf of his or her client, citing specific violations of the ADA. Examples could be the parking lot is not accessible for disabled people, or not as accessible as they're required to be. The front door is not wide enough as it should be under the law. Counters in the facility are too high. There's a 36-inch counter requirement. You don't have your entry space is not wide enough for a wheelchair, or you don't have enough space for a wheelchair to do a 360 turn or whatever. So those are kinds of the specific allegations that are typically made in these kinds of matters. Typically, an attorney will send a letter. You have your attorney get on the phone with the letter and try to get to the specifics of what the violations are. And typically these are resolved by, if there truly are violations, working out some sort of an agreement for the entity to make the facility ADA compliant. It's typically not a difficult procedure to go through. These latest letters that our clients have been getting are atypical because these seem to be form letters that have been sent to a lot of dental practices in particular. And they don't cite specifically in violation of the ADA. And basically wants the recipient to fill out a questionnaire and basically agree to a resolution process with the attorney who is sending out these letters. So it's a strange procedure. This person who has been sending out these letters has done this in other jurisdictions. I know that there were a number of lawsuits that this person has filed in the state of California for ADA violations. The attorney who is sending out these letters himself is allegedly disabled. And so I'm guessing that when he does file, if and when he does file lawsuits, he files on behalf of himself. And, I don't know what his true modus operandi here, if it's like in the other situations that I've dealt with, where they're just trying to get an entity to be in compliance, or if he's looking for more.
So in these cases, this lawyer has never been to any of these offices, doesn't actually know whether they're compliant or not, as far as we know, but that
is my guess. That's my guess.
That's your guess. And they have no record of this individual sending the letters and he's from out of state, having ever been there. So basically, they're getting a letter that demands that they prove that they're compliant from somebody that they don't know has ever been in their office, will ever be in their office, or even has a client that has ever been or will be in their office. So with this kind of letter, what is someone to do? What happens if they don't respond? And if they do choose to respond, what should they be saying?
Yeah, if they don't respond, they do run the risk. I don't know how severe of a risk it is, but they do run the risk of this guy either hiring or bringing himself coming in or having dummy clients come into a facility to check out the facility to see if it's compliant and follow it up with a lawsuit. I do know that this law firm has been involved in litigation, for instance, in the state of California. So that is a risk. How severe of a risk, I don't know. Because again, I'm of the opinion that a whole lot of these letters have been sent out. I think that, so you run the risk, and I don't know how severe it is. He might not react to anybody. One thing you can do is you can respond to the letter. I don't think I would respond to the letter by agreeing to his conditions or filling out his questionnaires. You can either respond or hire a lawyer to respond. Probably it's better to hire a lawyer to do it, but send a letter back to say to the fact, we're in compliance. If you have specific allegations as to how we are not in compliance, please give those allegations to our attention and we will deal with them. And sort of at that point in time, you put the onus on him to actually say, we've been to your facility. Your counters are too high. We've been to your facility. You do not have enough room in your waiting room for somebody to comfortably be in a wheelchair. If it's a dental practice, for instance, what are you? We've been to your facility and there's no room in your exam rooms for there to be a wheelchair. How do you treat a wheelchair patient? Those kinds of things. So I think if I were going to respond, that's how I would respond. I'd either send a letter myself or have a lawyer send a letter demanding that they give specific allegations and say, if we don't hear from you, we'll consider this matter closed.
Okay. So when you get a letter with specific allegations, you should respond. When you get a letter just kind of digging for information, trying to scare you into responding, you should talk to your lawyer and ask for more specifics.
Yeah, there is something else that parties can do. There are individuals who are titled certified access specialists. Typically, they're architects. You can go online. You can probably, if you truly have a concern as to whether or not your facility is in compliance with ADA regulations, you might want to contact one of these certified access specialists, have him or her come into your office and do a review and tell you what he or she thinks needs to be done. They will obviously charge a fee. I don't know what kind of a fee they will charge, but if you have some serious concerns, it's probably not a bad idea to hire one of these persons in the first instance. That is somebody who's going to be on your side, and see what's wrong, get yourself in compliance, and that helps you. That's your best defense in the event anybody wants to sue you in the future for non-compliance with ADA.
Okay.
If you have some concerns, for instance, let's say you're leasing a facility, okay? You have some concerns about the parking area and whether there's enough parking spaces for disabled people. Get in touch with your landlord. Say we have a notice from a lawyer who's threatening action against us. Please make sure that our parking lot here is compliant with ADA regulations. Please make sure that the outer doors to the building are in compliance with ADA regulations. So Those are other things you can do if you don't own your own facility. Obviously, if you own your own facility, let's say you have a standalone facility, and if it was built in the last 10 years, so I am guessing that you worked with your architect and your contractor and made sure that everything you put in there was ADA compliant. You might want to go back and go through the plans with your architect or the contractor because they know that what you were doing to make it ADA compliant. So there are things that you can sort of nip it at the bud
Okay.
to
So,
avoid a loss.
so I mean, obviously, buildings that are older, there are some carve-outs and exceptions. So it depends on the building you're in. And certainly, if you're entering into a new lease, it would be helpful to have a requirement that the landlord bring the building into compliance with the ADA should any issues arise. That would definitely help you if you have a landlord that's not too worried about, meeting your demands as well.
By the way, you mentioned older buildings. If you are in a building that's 3 or more stories, you better make sure that there's an elevator because that is a common claim that people can make that you're in a building that's not ADA compliant for a commercial building.
Right. Okay. So in terms of agencies that enforce ADA compliance, what kind of agencies are out there that can show up at your door or send you a notification that you actually do need to comply with? And how does that happen generally?
There's, for instance, if you're working in the city of Chicago, there's the Chicago Commission of Human Rights. There's also a Cook County Commission of Human Rights. Those kinds of commissions are not just limited to employment matters. They are designed to protect consumers as well. And ADA would come into the consumer protections. So do those entities actually come into your facility and say you're in violation? Probably not. Usually what you do is you get some sort of written communication from them. More likely than not, they might have gotten a complaint from somebody who was disabled who said, I don't believe that this facility is ADA compliant. Would you investigate? So at that point in time, they notify the entity of the complaint. They're obligated to investigate every single complaint. And you and your attorney work with the commission to try to make sure that whatever concerns exist are taken care of.
Okay.
It could
I
it
mean,
could be as simple as just repaving the parking lot because it might have been uneven, which would make it difficult for somebody in a wheelchair to navigate through. So it could be something as simple as that, or it could be even simpler, making sure that you have for your parking lot, make sure you have um, ADA accessible parking spaces, which are the right width. Make sure that they're easily marked, painted, and with signs. Could be as simple as that.
okay, makes sense. All right. So, any final thoughts on people out there who might be getting letters telling them that they're non-compliant, whether a patient has been in their office or not? Certainly, they shouldn't, necessarily be reaching out to that patient directly. I think they need to only respond to the lawyer who reached out to them or the government
Correct.
commission. We don't want to see any retaliation, obviously, against anyone. That should be very clear. But any other piece of advice that you want to share on this topic?
I guess in light of these letters, they should be on the lookout for new patients who might call up and say, well, I want to schedule an appointment with you. I'm disabled, and asking questions about what kind of what they've done to make their facility accessible. So they should be very wary about those kinds of conversations and say, well, just make it very simple. We're compliant. As I said, if they have any concern whatsoever that they're maybe not in compliance, check with a certified access specialist. I don't know how much they'll cost, but it might be as little as $500 or something just to have them come in and take a quick look at your facility and give you, maybe they'll even give you a certificate that you are in compliance, which is going to help you.
Right. A good offense is always the
Exactly.
best approach. So
Exactly.
all right, perfect. Well, I hope everyone listening to this found this topic helpful. If you have any questions or you received a letter similar to the one that we're describing, please feel free to reach out to Michael to ask any questions that you may have. And of course, feel free to reach out on any topic at any time to either myself or Michael. You can catch more of our podcasts at ralaw.com. This has been the Health Law Hotspot. Thanks for joining us.
The Roetzel Health Law Hotspot is made available by the firm and its attorneys for educational purposes and to provide general information, not to provide specific legal advice. Use of the Roetzel Health Law Hotspot does not create an attorney-client relationship between you and the firm or any of its attorneys. The Roetzel Health Law Hotspot should not be used as a substitute for competent legal advice, and you should contact an attorney in your state about any legal needs or questions you may have.